Our guest today is Dave Meyers, a partner of Troutman Pepper down in Richmond, Virginia. Dave is one of those jack of all trade lawyers, knows everything corporate law, securities law, corporate governance related. I've known him forever. I'm Brock Romanek, today on Zippy Point. All right, Dave, item 407I of Regulation SK, hedging disclosures. The mandate just started with the 2019 proxy, so it's still pretty new for us. So the length of this Vid-Guide is going to be longer than it probably needs to be, but since it's so new, I thought we should really cover the waterfront. So when is this disclosure required?
Well, thanks, Brock. It's really a pleasure to speak with you. And you're right, it is a relatively new topic. And so basically, just to go back, the idea is that most people have a general understanding that there's, certain forms of hedging, monetization transactions allow sort of a separation from the holder to, an officer to lock in the value of their stock holdings for often in exchange for all or part of the potential for upside appreciation in the stock. And the problem obviously is that these transactions allow, your covered individual, your director or your officer to continue to own the securities, but not with the risks of ownership. And so that was identified as a pretty serious issue over time between the different economic downturns. And so because of that, originally there was the SEC rule passed in 402B of SK that you needed to talk in your CD&A about if there's policies regarding hedging economic risk. Now, obviously, the CD&A apply to your NEOs, and so it didn't pick up everything. And so when they passed the Dodd-Frank Act, Congress mandated that the SEC pass rules, which, as you said, went into effect in July of 2019, that covers not just officers and directors, but employees. And so that's a long way of saying it now requires, when you have your annual meeting proxy statement, that you now have to disclose, and it's a disclosure rule, your policies and practices related to hedging. And so whether it's related to compensation or held directly or indirectly by the employer or director. So it's now in most proxy statements, at least for large accelerated filers since 2019.
And what constitutes hedging for purposes of this rule?
So the interesting thing is the SEC didn't really define the term hedging, or they wanted it to be broad because they believe, and which is probably true, that people are really smart, and if they were to come up with a definition, people would try to come up with workarounds. That's what they pay their lawyers for. So it's a pretty broad range of transactions that serve to offset a decrease in the market value of the covered securities. And so, and when they did the adopting release, they did talk about a broad principle, any type of transactions that have the same economic effects as the transactions that they specifically refer to in the rule, which are, as examples, prepaid variable forward contracts, equity swaps, collars, and exchange funds, which are a lot more complicated than I understand, but those are the things they're focused on. And so really they want companies to make their own judgments about the transactions that they want subject to the disclosure rules.
And sounds like any type of equity security would be covered by the rule.
Yeah, so they wanted it to be pretty broad, and they wanted to cover not just of the company, but also of subsidiaries, or if you're a director or employee of a subsidiary of the parent. And so they also want to cover convertible securities, warrants, convertible stock, things like that. So they want it to be pretty broad and make sure that it's not necessarily whether it's listed on an exchange, like just normal common stock, but much broader than that.
And also in terms of the scope, we're talking about NEOs and members of the boards.
Yeah, and also broader employees. Now, the interesting thing so they cover officers with employees. The interesting thing is, and again, we'll talk about this, but obviously it's a disclosure rule. So when they don't really define what they don't say all employees, they just say employees. So obviously I think for some companies, it might be the case that you don't want to, you want to define the universe of who you apply it to, and not necessarily every employee. But again, I think the idea is that they want it to be pretty broad-based, and they also pick up designees. So that could also, depending on who that is, it could be somebody like your family members or things like that. And again, as as you said, Brock, it's a disclosure rule. So it's really describing what specific policy you have implemented within that universe.
So if I understand the substance of the disclosure properly, we're talking about you describe your hedging policy, but you don't need to attach the policy as an appendix to the proxy or file it as an exhibit otherwise to the 10K?
It's either you could fully include your policy if you wanted to it's not an attachment as a separate, you don't have to have it because a lot of times you see it as part of an insider trading policy or things like that. So it's either a summary, pretty much of what your policy is, or you can include it, but it's not like a standalone policy like we used to see in the old days, like when the audit charter had to be attached.
And what do companies disclose if they don't have a hedging policy? Have you seen any examples of that?
I think, as is typical for the SEC, in my opinion, when they want people to have certain things, they often do it through disclosure rules. And so statistics bear this out. Almost all companies now have hedging policies. Most of them already had it because of the CD&A requirement and what ISS and Glass Lewis wanted to do. And so it would be very rare to see somebody who didn't disclose that they had a hedging policy. But again, it's the disclosure rule would be you would disclose why you didn't have the policy and why. It'd probably get you in trouble with ISS and Glass Lewis to do that.
And what about, I know the 407I talks about a fair and accurate summary of the policy. Typically, how detailed does that summary get about the policy?
It is relatively new in terms of the requirement. I think people have always in their CD&A have been talking about it. And now it's, you see it a lot of times outside this CD&A because of the new rule being broader than just your officers. And so we see a lot of our clients do summaries, pretty thorough summaries, which, a lot of hedging policies are not very long in the first place. And so it wouldn't be unusual just to, do either, pretty much summarize pretty thoroughly or to include the policy within the body because it's not going to be that long. So, but I think it's still developing as to what people do. I think most people plain language their policies into the proxy is what we usually see.
I would love it if they plain language the policy itself. Which
yeah, exactly.
They're pretty brief policies in most cases.
They're pretty brief, and so it's just, yeah.
What about disclosure about individual hedging transactions? Are those required to be disclosed?
Those aren't required to be disclosed, and so you generally don't see that. And generally, because there's the prohibition on hedging in general, I guess you could see a situation where for some reason you waive for some unique circumstance something. I haven't seen that, but you don't see individualized disclosures. I guess we'll talk a little bit about pledging, but you don't see it obviously with respect to hedging.
And where within the proxy is this disclosure typically located?
That is a great question. They don't really tell you where in the proxy statement it needs to be. It can be included in the CD&A if you want, or outside of it. Mostly we're seeing now it's outside of the CD&A with a reference in the CD&A because part of the problem is, putting it in, it just depends on if you put it in the CD&A, which really goes to NEOs. But the issue, I think, is that would be then covered by the SAM-Pay vote if it's in the CD&A. I'm not sure that's a big deal other than if you didn't get the SAM-Pay vote, then you'd have to question whether or not there's some issue with your hedging policies. So we're mostly seeing it outside in the general narrative disclosure after the compensation tables where you see the, different descriptions of other compensation arrangements and the compensation risk assessment, things like that.
And if it's located outside the CD&A, sometimes might there be some hedging disclosure within the CD&A and then?
Yeah, so you usually see some, at least with respect to the NEOs, you definitely would see some disclosure because it is one of the line items to consider. And also, then you'll usually see like a cross-reference to the more thorough discussion that's farther on in the summary comp narrative parts.
And then what are the typical terms of a hedging policy? What are sort of the must-have provisions, you think?
They're pretty broad about what they describe, focused on, covering instruments that do allow hedging. And so I think mostly what you see is they make sure that they cover what's inside the rule itself, which are the prepaid variable forward contracts, equity swaps, collars, and exchange funds. And then they, typically you'll see a sort of a capsule, anything similar to that. So that's usually embedded within the hedging policy. You usually see, even though it's already prohibited, you'll see prohibitions on short sales transactions, which are already prohibited under Section 16. And then a lot of times these are embedded within insider trading policies. It's sort of a standalone. We usually see them with, I guess it varies, but a lot of times we see them embedded within insider trading policies since those have to go to all your key people anyway.
So how should companies, you mentioned pledging earlier, how should
Yeah.
companies think about pledging in the context of their hedging policy? Do they address pledging as well?
I think there's a couple of things with that. So obviously the hedging rules don't specifically talk about pledging. There are SEC disclosure rules in the beneficial ownership table with respect to pledging. If your folks that are covered by the officers or directors have specific pledge transactions, those have to be disclosed in footnotes. And so you typically, since pledging is a different concept than the risks are different than hedging, you usually see it as a separate, you do usually see it accompanied with the hedging, either a standalone policy or within the insider trading as a separate provision, not intertwined with hedging, but as a separate standalone. And most companies will prohibit pledging subject to, extraordinary circumstances where you'll get the general counsel or the CEO to potentially waive it because, ISS focuses on significant pledging. And so being prohibitive, absent, there's a couple ISS carve outs for that, as there always is. But generally, most companies don't want to have executives, directors pledging stock. There was the famous Green Mountain Coffee situation a few years ago where I think it was both the CEO, maybe the chairman, but there was a number of executives who had pledged significant holdings of their stock, and there was margin calls because Green Mountain Coffee at the time had a 50% day drop, and they had to. It was outside of the windows, and so they had margin calls, and so that created a public relations nightmare. Even though it was legal, it looked horrendous, and I think that's part of the situation of why companies are, do not want to have pledging disclosures.
So I imagine investors are reading these first 2 years batches of disclosure and finding out if any of their portfolio companies have problems like that and would react accordingly pretty strongly. But otherwise, I imagine the hedging policy disclosures are sort of a whole hum thing, since they're mostly probably saying the same thing.
Yeah, they're pretty much standardized now. Unlike clawbacks, where they're all unique and different and they're complicated, I think the hedging policies and pledging are pretty standardized, and you haven't seen a lot of issues related to. You really haven't seen anybody violating, no hedging in general, and so they've been pretty standardized now, and you haven't seen a lot of reaction based on the disclosures. And again, I think because from the CD&A, people have sort of been already focused sort of on hedging issues before the rule mandated the disclosures for Dodd-Frank.
Yeah, they cleaned up their house before.
Yeah.
That was a long lead time between Dodd-Frank.
Yeah, very long lead time.
Thank you very much.
Thank you.